quotes and stuff like that, which we don't have. So you're going to have to concentrate extra hard. And also, some of the things I wanted to give you were references to things that I've written. So if you, the easiest way to find many things that I've written is to Google my name, David Hirsh, and Goldsmiths, which is my university, and find my Goldsmiths homepage, and from there are links to a lot of the things that I've written which are relevant to this discussion. So, I want to talk about the Ronnie Fraser case. For 10 years now, the campaign to boycott Israel has been gaining support within the trade unions that represent academics in Britain, as well as other trade unions. More recently, within some of the scholarly organisations in the US, such as the American Studies Association and the Modern Languages Association. The boycotters say that they are only for a boycott of the state or of institutions, a victimless boycott. But what is actually being created is a culture in which the exclusion of Israelis, and only Israelis, from the global community is coming to be seen as legitimate. The boycott is proposed as a response to Israeli human rights abuses. It is said that Israel is apartheid, like the old racist South African regime, and should be similarly shunned. The phenomenon of Israel boycott is significant because it sits at the nexus between concern for Palestinian freedom, criticism of Israeli policy, hostility to Israel, and anti-Semitism. The boycott goes beyond criticism of Israel by aiming to create a concrete exclusion of ordinary Israelis. This exclusion is set up in the UK, in Ireland, in South Africa, in the USA. It is set up here, not far away in the Middle East. So it's not only about Israel, it's also about what happens on our campuses. The boycott campaign is not anti-Semitic in its motivation, but arguably it is anti-Semitic in its effects. Its proponents are not Jew haters, but they do set themselves up in a fight against the overwhelming majority of the world's Jews. The boycotters seek to punish Israel for human rights abuses and to hold all Israelis collectively responsible for the actions of their government, while they target no other state for boycott and they seek collective punishment for no other citizens. People who oppose the boycott campaign tend to be forced into one of three responses. One can stay silent, one can help to legitimize the campaign for boycott, or one can agree or be forced into the position of standing in the dock for Israel. Those who oppose the boycott campaign are in danger of being treated as though they are enemies of Palestinian freedom and apologists for racism, apartheid, and colonialism. Most of the people forced into these options and treated as pariahs are Jewish. In fact, the choice impacts on Jews in a particular kind of way, which I think is relevant to some of the issues in this case. Images and tropes from old anti-Semitic themes are often unconsciously recycled, and Jews who oppose the boycott are framed as conspiratorial, powerful, rich, bloodthirsty, particularly against children, bourgeois, connected to dishonest bankers, warmongers, and such like. Yet, boycotters tend to become enraged when the issue of anti-Semitism is raised, and they tend to respond not by examining their own rhetoric and aims, but with an angry counter-accusation. They tend to respond that the person who raises the issue of anti-Semitism is doing so in bad faith, not because they are really concerned, but in a dishonest attempt to frighten people from criticising Israel. This is what I've called the Livingston formulation. It is the key mechanism by which people who are otherwise good at recognising racism and bigotry fail to recognise or to engage with contemporary anti-Semitism. Ronnie Fraser had been opposing the boycott campaign and being he called himself a friend of Israel within the academic trade unions in the UK for the last 10 years. First in NAPFI, the National Association of Teachers in Further and Higher Education, and then when it merged into UCU, the University and College Union. He teaches maths to 11 to 18-year-olds. He's not an academic. By 2009, most of the other Jewish activists who had been opposing the boycott campaign within the union had, in one sense or another, been driven out, banned, bullied, intimidated. Ronnie was pretty well the only Jewish guy left who was able and willing to oppose the boycott at UCU Congress. Ronnie's kind of stubborn. In 2011, the union passed a motion disavowing the EUMC working definition of anti-Semitism. It did this because it wished to continue doing things which, within that framework, could be judged to be anti-Semitic. Before it overwhelmingly voted to ignore him, Fraser said the following to Congress, quote, "Congress, imagine how it feels when you say that you are experiencing racism and your union responds, stop lying, stop trying to play the anti-Semitism card. The overwhelming majority of Jews feel that there is something wrong in this union. They understand that it is legitimate to criticize Israel in a way that is, quoting from the definition, similar to that levelled against any other country, but they make a distinction between criticism and the kind of demonization that is considered acceptable in this union." I was with Ronnie after he made the speech outside the conference hall in Harrogate. I saw him, a courageous, tough teacher, a grandfather, a son of Holocaust survivors, break down after having been treated with contempt by 300 of his union colleagues at Congress. I saw the anti-Semitism, which was normal within the UCU, make him cry in pain and in isolation. The union, which is so ready to hear about other racisms with compassion, listened to Fraser with a glass ear. Later, it was to instruct its lawyer, Anthony White, to subject him to 2 days of cross-examination, in which he was accused relentlessly, articulately, and professionally of crying anti-Semitism for trumped-up political reasons. For Fraser, the rejection of the EUMC definition was the last straw. He judged that the institutional anti-Semitism which had become endemic within the UCU was in violation of the Equality Act of 2010. Fraser went to an employment tribunal, the court that adjudicates claims under this act in the UK, and he asked for its protection. His letter to UCU General Secretary Sally Hunt, written by his lawyer Anthony Julius, said that the UCU had breached paragraphs 26 and 57 of the Equality Act 2010. Quote, "That is to say, the UCU had harassed him by engaging in unwanted conduct relating to his Jewish identity, a relevant protected characteristic, the purpose and or effect of which had been and continues to be, and this is in the words of the Act, to violate his dignity and or create an intimidating, hostile, degrading, humiliating and or offensive environment." So he had to prove one of those things. The letter alleged a course of action by the union which amounted to institutional anti-Semitism, and it gave examples which I will come to shortly. The UCU defended itself vigorously. It said that it was an anti-racist union, that it vigorously opposed anti-Semitism, and that Fraser was illegitimately trying to frame his political defeat as a friend of Israel in terms of anti-Semitism. The union had done nothing inappropriate, it claimed. The tribunal sat in the autumn, the fall of 2012. It accepted evidence on behalf of Fraser from 34 witnesses. Union activists, scientists, sociologists, historians, lawyers, philosophers, members of parliament, Jews, Christians, Muslims, atheists, academic experts on anti-Semitism, Jewish communal leaders. Witnesses gave written statements and were subjected to cross-examination. A coordinated campaign by Ronnie Fraser, his lawyers and his witnesses to try to intimidate critics of Israel with an invented accusation of anti-Semitism would indeed be vile and disgraceful. This is what the tribunal in the end concluded had been happening. And this explains the unusually intemperate and emotional language employed in its dismissal of Fraser's case. This also explains the tribunal's refusal to consider with seriousness the detailed evidence which the witnesses presented of how anti-Semitism functions within the UCU. You can easily find the full written judgment online. It's published, and it's kind of interesting reading. The tribunal found against Fraser on everything, on technicalities, on legal argument, on every significant issue of substance and of fact. The tribunal found everything the UCU said in its defence to be persuasive, and it found nothing said by Fraser or any of his witnesses to have merit. The culture, the practices and the norms inside the union were found to be not anti-Semitic, either in intent or in effect. Indeed, everything Fraser and his witnesses experienced as anti-Semitic, the tribunal judged to have been entirely appropriate. In particular, what was appropriate was the way that union staff, rules, structures and bodies had operated. Fraser said that there was a culture in which anti-Semitism was tolerated, but the tribunal did not accept that even one out of the very many stories that it was told was an indicator of anti-Semitism. Instead, the tribunal found that, quote, at heart, the case represented an impermissible attempt to achieve a political end by litigious means. What political end? Well, the only possible political end is an attempt to defeat or silence campaigns against Israel. This would certainly be impermissible in an employment tribunal which is rightly concerned with issues such as anti-Semitism, racism and sexism. Of course, the fight against anti-Semitism is also political, but this cannot be the kind of politics to which the tribunal objected. If it was, then it would find every allegation of racism, sexism or homophobia, for example, also to be impermissible. Opposition to anti-Semitic politics has always been central to campaigns against anti-Semitism. The tribunal makes clear that it meant Fraser was trying to mobilise a bad faith allegation of anti-Semitism in order to silence good faith critics of Israel when it goes on in the next paragraph, and I quote, "We are also troubled by the implications of the claim. Underlying it, we sense a worrying disregard for pluralism, tolerance, and freedom of expression." The tribunal says that Fraser was trying to fool it into outlawing and branding criticism of Israel as anti-Semitic. Of course, every racist claims that anti-racists disregard their right to free speech. True, sometimes the tribunal appears to veer towards the view that those who complain of anti-Semitism are simply oversensitive and lacking in objective judgment, but the central findings that this is politics dressed up as litigation and that this is an attempt to disallow free criticism are allegations of bad faith. Anybody who's been following the story within the union will be aware that the response of the tribunal is precisely the same as the response which opponents of anti-Semitism and of the boycott campaign were faced within the union. The tribunal backs the union's way of thinking about anti-Semitism 100%. The experience of going to the tribunal, it turns out, is more of the same experience about which Fraser appealed to the tribunal in the first place. Fraser said that the key mode of intimidation in the UCU was a constant allegation of bad faith. The allegation that Jews who say they feel anti-Semitism are actually lying for Israel. The tribunal replied that Jews who say they feel anti-Semitism are actually lying for Israel. They are dressing up a political end as a problem of racist exclusion. In other words, the tribunal answers that the accusation of bad faith made against Jews who say they experienced anti-Semitism is appropriate. The tribunal employed the Livingston formulation. Fraser argued that there were a large number of incidents which should be understood as exemplifying a culture whereby anti-Semitism was accepted as normal within the Union. He called 34 witnesses to tell the tribunal about the anti-Semitism that they had seen. They told the tribunal about a number of incidents they had witnessed and experienced. In 2006, Ronnie Fraser stood as a delegate to NAPFI conference. It was said at a regional meeting that Fraser could not be a delegate because he was a Zionist and therefore a racist. NAPFI held an investigation and they found that this statement had not been anti-Semitic. Israel has been relentlessly condemned at every UCU Congress, often by motions to boycott Israel. There were no motions to boycott any other states. The parliamentary inquiry into anti-Semitism reported that the boycott debates were likely to cause difficulties for Jewish academics and students, to exclude Jews from academic life, and to have a detrimental effect on Jewish studies. The UCU responded that these allegations were made to stop people from criticising Israel. 76 members of the UCU published a critique of the union's response, but the union took no notice. John Mann, Member of Parliament, told the tribunal that UCU had been unique among those criticised by the inquiry in its refusal to listen. Sean Wallace, a local UCU official, said that anti-boycott lawyers were financed by, quote, bank balances from Lehman Brothers that can't be tracked down. Ronnie Fraser asked him whether he had indeed made this arguably anti-Semitic claim. Wallace admitted having said it, but it was Fraser who was, for the crime of asking, found to have violated union rules concerning, quote, rude or offensive communications. Gert Weiskirchen, Gert Weiskirchen is a member of the Bundestag, a German Social Democrat. He was responsible for combating anti-Semitism for the OSCE, the Organisation for Security and Cooperation in Europe. He asked the union leadership for a meeting to discuss anti-Semitism relating to the boycott. The union did not meet with him. When 39 members of the union protested publicly, the union ignored them. It's quite an interesting example because the union could easily have sent somebody to sit with him for half an hour and then ignore him, but they chose instead to rebuff him. The union invited South African trade unionist Bongani Masuku to speak at a pro-boycott conference in London. They paid for his flight and everything. Masuku was known to be under investigation by the South African Human Rights Commission for anti-Semitic hate speech. Here is an example of what Masuku had said. Quote, Bongani says hi to you all as we struggle to liberate Palestine from the racists, fascists and Zionists who belong to the era of their friend Hitler. We must not apologise. Every Zionist must be made to drink the bitter medicine they are feeding our brothers and sisters in Palestine. Masuku also said that vigilante action would be taken against Jewish families suspected of having members serving in the Israeli military, and Jews who continue to stand up for Israel should, quote, not just be encouraged but forced to leave South Africa. The union ought to have known Masuku's record. Ronnie Fraser himself told the union about Masuku's record. Masuku was found guilty in South Africa of hate speech before speaking as a guest of the UCU. And months later, UCU Congress explicitly rejected a motion to dissociate itself from Masuku's, quote, repugnant views. So what I'm doing here is going through a number of the issues that were raised in the trial. Yes? The activist list is an email list hosted by the union. Ronnie Fraser argued on the list that there was no absolute blockade of Gaza in response to claims that there was. In response to this email from Ronnie, another member of the union said that he was like the Nazis at Theresienstadt. The union found that there was nothing inappropriate about this comment. Josh Robinson put together a detailed formal complaint about anti-Semitic language being employed by members of the union on the list. He documented how people who opposed anti-Semitism on the activist list were routinely accused of being, quote, deranged, crazy, nutters, Israeli agents, hysterical, dishonest, twisted, rotten Zionists, that one was from me, less than human, believers in a promised land, motivated by the fairy story of the Old Testament, genocidal, accepting of the murder of innocents, racist, pro-apartheid, supporters of ethnic cleansing, Nazis. The Holocaust was referred to as an attempted genocide. There followed volleys of insults made against those who raised concerns about this description of the Shoah. The formal complaint was given to Tom Hickey to adjudicate. Hickey himself, the tribunal was told, had said that Israel is, quote, more insidious and in some sense nastier than Nazi Germany. In the end, nobody even bothered to tell Josh Robinson that his complaint had been dismissed by Tom Hickey. A number of other people made similarly careful formal complaints. The union did not once ever find anything complained of was anti-Semitic. A significant number of union members resigned over the issue of anti-Semitism. Congress voted down a motion to investigate the reason for these resignations, yes? There was no mechanism for counting resignations over anti-Semitism, and such resignations were instead counted as being because of disagreements over the Middle East. People who complained about anti-Semitism in the union were routinely confronted with accusations that they spoke in bad faith. They were told that they were making it up in order to try to silence criticism of Israel. In court, Sally Hunt, the General Secretary of the union, was asked a question under cross-examination. She was given a hypothetical. If somebody said, if you want to understand the Jews, read Mein Kampf, would that be anti-Semitic? She answered that it would not necessarily be anti-Semitic in the context of the union. The tribunal heard about all these events and, like the union, judged none of them to be evidence of anti-Semitism. It said in para 156, the claimant is a campaigner. He chooses to engage in the politics of the union in support of Israel and in opposition to activists for the Palestinian cause. When a rugby player takes to the field, he must accept his fair share of injuries. Similarly, a political activist accepts the risk of being offended or hurt on occasions by things said or done by his opponents, who themselves take on a corresponding risk. It is unimaginable that a tribunal would say the same thing to a woman who complained of sexual harassment at work after she chose, for example, to wear a tight skirt to the office, or after she had chosen to campaign in favour of women's rights. But this is what the tribunal said to a Jewish guy. The rugby analogy demonstrates one of the central problems with the approach taken by the tribunal. On the one hand, the tribunal was unable to make the distinction between arguments about Israel and Palestine, and on the other hand, evidence of anti-Semitism. The result is the position that since Fraser took on the responsibility of defending Israel, then he should expect some anti-Semitism as part of the game. The tribunal also mentioned that it had been inappropriate to allow Tom Hickey, a union official, to sit in judgment over formal claims of anti-Semitism. Why? Why would it be inappropriate? according to the Tribunal. The Tribunal says in para 181 that the reason is that he is a well-known pro-Palestinian activist. Well, what's the relevance? Why should a pro-Palestinian activist be unqualified to judge what is anti-Semitic and what is not? Being pro-Palestine should be one thing and being anti-Semitic should be quite another. The Tribunal found itself unable to understand the distinction. The reason why Hickey was an inappropriate judge, as the Tribunal was told, was because he was not good at making the distinction between anti-Semitism and criticism of Israel. Not because he was pro-Palestinian. Fraser had offered the Tribunal a video to watch which showed Hickey saying that the attempt by Israeli archaeologists to write a history of Israel as something which had always existed was more insidious and in some sense almost nastier than the Nazi genocide of the Jews. Israeli archaeology, yes? The Israeli creation of a national narrative, nastier than the genocide of the Jews by the Nazis. This extremist position, which many would judge to be anti-Semitic, was the reason that this man may be judged to be inappropriate to judge a formal complaint of anti-Semitism. But the Tribunal refused to watch the video, and it misconstrued the points about why he was an inappropriate judge. Speaking for myself, I never chose to play rugby. I found that my union was considering setting up an exclusion of our Israeli colleagues from UK campuses, so I tried to make arguments against it doing so. I was, as it were, pushed onto a rugby field. There I found myself being outnumbered and repeatedly knocked to the floor by organised opponents. I was confronted by relentless, if usually subtle, anti-Semitic rhetoric, hostility and accusations of bad faith. I appealed to the union, which was playing the part of the referee, but the referee said it was neutral between the two teams, and I should just get on with the game. But I wasn't part of a rugby team, and I didn't want to play. I only wanted my union to stop with the hatred of Israel and with the anti-Semitism which came with it. And when I tried to step out of the rugby field and to say publicly what was going on, I was then punished for breaking the rules of the game. While I'm talking about my own experience, please indulge me a little while I tell you about a couple of others. Although the witnesses told the Tribunal about hundreds of incidents, my own happened to be clearest in my own memory. There was a time when I and a number of others, many of whom eventually gave evidence for Ronnie, in front of the Tribunal, were trying to have our voices heard on the activist list inside the union. Most of us, unlike Ronnie, were not particularly pro-Israel, but were strong critics of Israeli policy and of the occupation. Indeed, some of my own criticism of Israel was so strong that it was read out to another witness under cross-examination as being indistinguishable from the anti-Semitic rhetoric of which Ronnie Fraser had complained. The witness in question explained to the Tribunal how it was different. Nevertheless, if ever we raised the issue of anti-Semitic rhetoric on the list, we would immediately be denounced for crying anti-Semitism in bad faith in order to silence criticism of Israel. It was a difficult time. We would try and explain what the problem was with the accusations that we supported the genocide of the Palestinians, or that we were racists, or that we were Nazis. And people would respond immediately, relentlessly, and in writing before hundreds of our union colleagues, that we only raised the issue of anti-Semitism in order to stifle their criticism of Israel. We appealed to the moderator of the list. We said that this was a union space and it should not be possible to bully us out of it with anti-Semitic rhetoric. But the moderator acted as the referee in a tough match between Israel and Palestine, rather than as a union official making sure that the union was a safe place for British Jewish trade unionists. One academic who had been particularly active at the time, a friend of mine, told the tribunal that he had nearly had a nervous breakdown because of the way he was treated on the activist list. The tribunal explicitly praised his evidence in its judgment, but it didn't listen to his evidence, and it didn't discuss his evidence in the judgment. It simply said that he was a good chap. One strategy I was minded to adopt at the time was to publish some of the anti-Semitic material from the list on the Engage website, on our website. There was a closed culture within the union in which anti-Semitism was never recognised and was never thought to be a problem. Institutional racism requires a heavy policing of the institutional boundaries to make sure that the values of the external world cannot intrude and the norms of the internal world cannot be seen. In August 2007, I wrote an email on the activist list expressing concern at the anti-Semitic consequences of the campaign to boycott Israel, and arguing that we should be aware that it is usual for anti-Semitic arguments to be positioned as one side in a legitimate democratic debate. That's what anti-Semites try to do. Holocaust deniers, for example, always try to position themselves as one side of a legitimate debate about whether the Holocaust happened, yes? I was warned by the list moderator for the crime of saying this and told to be, quote, more careful in my choice of language, otherwise I would be excluded from the discussion. I was also told not to publish anything which appeared on the list. I responded by saying that I would make no undertaking whatsoever not to publish anti-Semitic material from the list. The tribunal tells this story in its judgment, but it chooses to delete the word anti-Semitic. In para 93 of the judgment it reports, quote, Dr. Hirsh responded stating that he would make no undertaking whatsoever not to publish material from the list. The word anti-Semitic is gone. I and other critics of anti-Semitism were indeed excluded from the list, while nobody was ever excluded from the list for writing anti-Semitic things. Indeed, nothing that happened inside the union was ever judged to be anti-Semitic. The tribunal judge himself asked me whether I broke the rules. I told him that as a whistleblower, I thought there were two conflicting principles. The tribunal chose not even to consider or to describe the dilemma in its judgment, but to omit the word anti-Semitic from my refusal not to publish material. I also, as a witness, told the tribunal that the key mode of intimidation in the union is the relentless, constant accusation of bad faith directed mostly against Jews. It was normal to suspect Jews of lying if they raised the issue of anti-Semitism. When people raise the issue of anti-Semitism, they are not to be believed. Because really, it is said, they are only trying to silence legitimate criticism of Israel. In January 2010, I was asked by the union to speak in Brighton on the topic of anti-Semitism, the Holocaust and resistance yesterday and today on the occasion of Holocaust Memorial Day. Still don't quite understand why they asked me. It was either a cock-up or some cunning plan. Anyway, they asked me. I talked about the record of anti-Semitism within the union. Tom Hickey, the character we've already discussed, a union official, an academic colleague, a philosopher, in public and in front of the General Secretary, said that everything I had said was a traducement of the truth, a straightforward lie, and the author knows it. The allegation is not that we are hysterical or that we make a mistake or that we see anti-Semitism where it doesn't exist. That's not the allegation. The allegation is that we lie. We make it up. We wield this weapon of Jewish power, which is to make an allegation of anti-Semitism and everybody is defeated by it. I explained the significance of the relentless accusation of bad faith to the tribunal. In their description of the event, they write in their judgment, quote, Mr. Hickey responded to Mr. Hirsch's remarks. He denounced them as unwarranted and false. He didn't do that, did he? The point of what he did was to say they are a lie and the author knows it. So again, the tribunal well, I don't know if they heard what was said or if they read what was written in the witness statements, but they reported it in a different way. The tribunal decided not to consider the point about the relentless bad faith allegation. It just left it out of its description and out of its deliberation. The difficulty of explaining what has happened in the union and what is wrong with the tribunal's judgment is that it is always necessary to descend into detailed stories and analysis of stories. There is no silver bullet. Rather, there are long and winding complex narratives, all of which require interpretation. There is no shortcut to understanding the everyday harshness of being Jewish in the University and College Union. I offer just two stories here. There were 34 witnesses who gave evidence about the culture of anti-Semitism in the Union. Each told long, complex and nuanced stories. The tribunal wrote them off in an explicitly disrespectful way as people, quote, ventilating their opinions. Paragraph 149. A very large number of incidents from over the years are clearly documented on our website. Whatever it is that Ronnie Fraser suffered within the union, he has now suffered doubly in the tribunal. That which he experienced as anti-Semitic was not only judged by the union, but now also by the tribunal not to be anti-Semitic. Further, it was also judged to be entirely appropriate. Ronnie complained that he was constantly accused of speaking in bad faith. The tribunal responded that those who raised the issue of anti-Semitism did indeed speak in bad faith, chose to play a rough game, and got what was coming to them. The old Romanian Communist Party used to win elections with 100% of the vote. Just this fact is enough to tell us that the process could not have been fair. The UCU and now the tribunal have judged that nothing that ever happened in the union was anti-Semitic. Not one thing, zero. Given the history of anti-Semitism in Europe and on the left, given the hostility to Israel and to Israeli policy within the union, it is hardly plausible that hostility to Israel was never expressed in an anti-Semitic way. An anti-racist union has a responsibility to educate and to guard against anti-Semitism. A tribunal has the responsibility to recognise anti-Semitism when it occurs and to protect those who are bullied by it. But we live in a time and in a place where it is possible for a union and a tribunal to fail to see anti-Semitism, even when it is shown to them in detail and even when its significance is explained to them. One footnote, well, I don't know if it's really a footnote to finish, is that the story is still going on, because after Ronnie was completely defeated and rather humiliated by this judgment, the union then came looking for costs, and they have sued him for £500,000 worth of costs. In other words, they're after his house. I can tell you more about that if you're interested, but I think they might not get it, actually, funnily enough. Anyway, it goes on. Thank you very much. I'm very happy to discuss and to take questions. Yeah.
Could you explain sort of the legal structure? Is the tribunal administrative or judicial? Is there appeal from it?
It's a court. It's the court which was set up. It's a system of. It's a court system which was set up for the judgment of the Act. So, in other words, the Act is meant to protect people at work fundamentally against institutional racism or constructive dismissal, that kind of thing. So it's set up to be a kind of lightweight, easy way for people to get justice against their employers. And it's a system, and it's actually a fairly new. The Act is a fairly new Act, brings together a whole load of case law, and it's a system which understands the concept of institutional racism and institutional sexism and those kinds of things in general. There was a paragraph in the judgment which it's kind of said that it used very strong language. It was outrageous that that the tribunal was abused by this, when it's meant to be set up to be used by ordinary people to challenge bullying. You see what I mean?
Yeah. My question is, in the UK legal structure,
Yeah.
we have such similar special purpose courts or administrative bodies.
Yeah.
But then there's usually an appeal
Yeah.
from that to the more general courts.
Okay. There could have been an appeal to actually the Employment Appeals Tribunal, so it has its own structure. And I suppose, I don't quite know, but I suppose notionally there could have been appeals to higher courts after that. But actually, Ronnie was already frightened for his house, and there wasn't really the muscle or the support to go to appeal. And I mean, the judgment was so devastating that I suspect Ronnie had enough, really. What can one say? I suppose there are good reasons to believe that he would have had a good chance on appeal, but he didn't really have the muscle, I think, is the answer. Yeah.
What percent of academics are represented by the UCU? Are there other professional academic unions that would stand in contrast
Not really.
to it?
The UCU is big. There was a merger between these two previous unions. A fairly high percentage are represented by it, but of course the decision-making bodies of the union are small. So the way it works really is that somebody does all the work in a branch, and as a reward they get to go to Congress. On the other hand, of course, if people were really concerned about what was being done in their name, they would stop it. So on the one hand, yeah, there's a sort of undemocratic coterie of people who make the decisions. On the other hand, one doesn't really want to get involved. I mean, we got involved and it was hard work, as I think you can see from some of the stories that you've heard. And, you know, academics have got better things to do, really, than wrestle with these people in this way forever. What one sees, for example, there was a boycott motion in the National Union of Journalists a few years ago, and it was defeated by a number of activists, mainly Jews, who came together and, you know, did what good trade unions do and defeated the motion. The problem was, of course, it comes back. So the people who spent half a year fighting this boycott resolution, then they have to spend half of the next year and, in fact, half of their whole life. And as I said, most people in the UCU, there was quite a lot of people in the UCU who were worried by the boycott. In fact, we had some early victories at Congress, but it wore everybody down. And in the end, Ronnie was the stubborn one who was left, really.
So, what percentage of academics are in the UCU, and can you have a successful academic career without being in it? And do they get funded by monies other than membership dues? And so where does it
I don't know the percentage. Quite a lot of, I mean, most people in my department are a member of the union. I've never left the union. I'm still a member of the union. And the reason I'm still a member of the union is because I won't be pushed out. You know, I just won't allow that to happen. At the moment, there's you know, normal trade union issues. There's a struggle over a contract next year. There's the possibility of strike action. And I don't want to be the one who has to walk out of the room and say, I'm not part of this. Yeah? No, the money comes from dues. But, you know, academics are under pressure, education is under pressure, and people consider the union as being something which defends them. Yes.
Well, when you lose a rugby match or a other sporting event, it's quite common to rationalize it by blaming the ref and saying that they're against you. Oftentimes amounts to sour grapes because you don't want to admit that you didn't perform well enough and that the other team was better.
Sure.
Now, a lot of people take a very different viewpoint of this case, such as you must know Jonathan Goldberg, who called this case a very legally flawed, epic folly that would impact negatively on the Jewish community for many years and never should have been undertaken in the first place. So you don't represent the only view on this case, do you? I mean, there are other ways to approach this that may be even more persuasive. We heard your side, but we haven't heard anybody else's.
Sure. Well, Jonathan Goldberg is a lawyer. He did make those criticisms of the case. But it seems to me that if you say that the case should never have been brought, then you have to be clear about what it is you're arguing. So, do you argue, is the argument that the 2010 Act doesn't protect a Jew from anti-Semitism in the Union? Or is the argument that there was no anti-Semitism in the Union? Or is the argument that the case wasn't put correctly? Or is the argument that one should not have gone to a British court because Jews could never get justice in a British court? And actually Goldberg never was specific about what was his position. I don't know if you have one of those options in mind.
Well, I think you have your day in court, and you just can't accept the decision as far as I'm concerned. And if you don't want to appeal it, then what can anyone else do?
Okay, so you're not prepared to say...
Well, he said it was legally flawed. I haven't studied it from a legal vantage point.
So then the argument...
His opinion on that.
Right, so then the argument is that the 2010 Act doesn't protect against institutional anti-Semitism, yes?
Yeah.
Yeah. So, for example, there was a lot of discussion in the judgment about Jewish identity as a relevant protected characteristic under the Act.
Also, whether that included attachment to Israel as a factor of Jewishness per se.
Yeah. So that was one of the arguments made by the Union. In fact, the Union and the Tribunal had a very strong position, which was to say there is no, quote, there is no relationship between a Jewish identity and any kind of attachment to Israel. There's no relationship between the two. But the Employment Tribunal routinely operates in a different way in different issues. So let me give you an example. If an employer acts in such a way as to penalise employees with children, right? To make it very difficult to retain your job if you have children and if you have childcare responsibilities, then one might say, well, having children, obviously that would be a sexist outcome, yes? If an employer makes it impossible to work if you have childcare responsibilities, there would be a sexist outcome from that policy, yes? But one would not then say that childcare responsibilities is a non-contingent part of your female identity, and neither would one say that only women have childcare responsibilities. Yeah? So a man could come along and say, I've got childcare responsibilities, I'm also being excluded, so how can it be sexist? And another woman could come along and say, I don't have children, I don't want children, I don't like children, therefore I'm not impacted by this policy. Yeah? So the question of relevant protected characteristic is recognised to be more complex. Let me give you another example. Imagine you had a trade union which said rap music is immoral and sexist. And imagine there was a campaign in the union against rap music. We could all see that a campaign against rap music would, in all likelihood, become a racist campaign. Yes? It would impact against black people, the rhetoric of the campaign would become racist, the campaign would in reality impact against black people in an unacceptable way. But again, nobody would want to say that liking rap music is a non-contingent part of a black identity, and nobody would want to say that only black people like rap music. So similarly, there is a relationship between Jews and an attachment to Israel, and it's not an irrational relationship. Nevertheless, of course, some Jews will stand up and say, well, I've got no attachment to Israel whatsoever, and when people say that the Zionists are Nazis, that doesn't impact on me in any sense. And on the other hand, some people who are targeted by that kind of rhetoric are not Jewish. So we had some colleagues who stood with us, stood by us, not Jewish, but were accused of lying in order to delegitimize criticism of Israel, were accused of being Nazis, of pro-apartheid and the rest of it. So the issue about the relevant protected characteristic is actually rather interesting. There's another issue relating to it, I think, which is that the law in England defines categories which it protects. So the law defines a category of Jew which it sets out to protect under the Act. But what actually happens in racism is that the racists define the categories that they wish to attack. So in other words, one can be designated as a Zionist and therefore a Nazi and therefore pro-apartheid and therefore an apologist for genocide, even if one isn't. Even if one isn't Jewish, even if one doesn't support Israel, whatever. So there's an interesting disjuncture between the way that the law defines its protected characteristics on the one hand, and on the other, the way that racist movements actually operate in a discursive frame. Yeah.
How was this reported in the British press?
How was it reported in the British press? It was reported very little in the British press. There was very little. Actually, it wasn't a story really. You know, it was. It was considered a non-story. It was considered, you know, Jewish guy goes to court and loses. With weak case, really.
There was no editorialization about the issues?
Very little. Very little. Yeah.
I realize that you're not American, but can you speak to what's going on in college campuses in the U.S. among academia?
Well, I think that the situation is not that different. I mean, I think one of the interesting things, one of the key rhetorics, for example, in the MLA discussion, the Modern Language Association discussion, also the ASA, the American Studies Association discussion, one of the key rhetorics is that people sort of stand up and defend their freedom of speech against this charge of anti-Semitism. So the charge of anti-Semitism is always portrayed as being a kind of bad faith allegation. Yes, it's always portrayed as being a way of that certain people try to stop criticism of Israel. And I think that's quite menacing. I think there's a discourse of kind of Jewish power which underlies that rhetoric, which I think we should be concerned about. I mean, I think it's fundamentally the same discussion. Of course, the boycott campaign is a global campaign. It's a global campaign to put Palestine and Israel at the centre of the concern of all anti-racists everywhere. In other words, it's a global campaign to find that Israel and Palestine is symbolic of a much, much wider struggle. And that in itself I find quite threatening, because of course anti-Semitism has always placed Jews at the centre of the world. Jews are very small in number, very small in power, very small in influence, yet anti-Semitism constructs Jews as being central to the world. For example, behind wars, behind revolutions, responsible for everything that goes bad in the world. And this goes back a long way in terms of Christian anti-Semitism and Jews being responsible for the failure of Christ to bring us redemption, yes? The rejection of Christ by Jews. So this symbolic identification of Jews as being central to everything that happens in the world, I think, is mirrored in some of the rhetoric we see in the boycott campaign. So On Israel's northern border, there's 180,000 people have been murdered, civilians have been murdered, have been gassed using sarin. 1 or 2 million or more, 3 million people are displaced from their homes as we speak. The slaughter goes on. The British and the American governments refuse to do anything about it. On Israel's southern border, the Muslim Brotherhood, which is of course the Egyptian wing of Hamas, or the other way around, 500 members of the Muslim Brotherhood have just been sentenced to death by the military regime in Egypt to be executed. The military regime in Egypt has completely closed down with a kind of vice of terror against the Muslim Brotherhood. There are huge events going on, and it becomes ever more eccentric to understand the little local fight between Israelis and Palestinians as being symbolic of everything in the world. That it should be the key issue here at Harvard. That here at Harvard, the key issue should be excluding Israelis from our campus. It's ever more eccentric, I think. Yeah.
So, Kerry said today that Israel is apartheid, and it hasn't been publicized at all. And yet, when an owner of the basketball team asked his girlfriend in a private conversation not to invite black people with her on his dime and his ticket, it gets published.
Yeah.
That's a little bit uneven.
I don't know what John Kerry said today. I think what John Kerry was saying is he was worrying about the possibility that sometime in the future.
No, he claimed that today Israel is apartheid.
Okay, well, I'd like to see the quote, really. I hope he didn't say that. Okay. Well,
Considering his grandfather is Jewish, I hope he didn't say that.
okay, well, if he said that, then I shall be writing about that in the morning.
Yes, please.
His grandfather was Jewish, you can't say?
Yes. His grandfather is Jewish.
Just prove that point.
Which one?
There's no connection between the two. No man's Jew to say it's apartheid. You can't not say it's apartheid because you're Jewish. It's because if it's something that you believe in, it shouldn't be affected by some predisposed position based on your race.
So it's an interesting point, actually, that to what extent having a Jewish identity enables you to speak with authority about antisemitism or about these issues. Of course, it's one of the key rhetorics of the anti-Zionist Jews, that the anti-Zionist Jews always mobilize a Jewish identity in order to give themselves extra weight. So you always hear, and it's very important within the union, that one should remember also that the boycott campaign in the union is partly significantly led by Jews. And not only is it significantly led by Jews, it's significantly led by Jews who say that nothing that we've heard tonight, nothing, has got any relation to anti-Semitism, and that when Zionists are denounced as being apartheid or Nazi, that has nothing, no connection with anti-Semitism. So for example, imagine, and this happened going back to the early 80s in the UK, that there was a campaign which tried to ban Jewish societies, tried to ban them from the campus. And the argument was Jewish societies are Zionist, therefore they're racist, therefore they should be banned. Now, what follows from that is that there are people teaching young activists to relate to Jewish societies as though they were Nazis on campus, as though they were apologists for racism on campus. And when you have a social movement which relates to Jewish communal bodies on campus as though they were Nazis, then you certainly have a campaign which is likely to throw up anti-Semitic results. When you treat Jews in general as though they're Nazis, even when you allow people to disavow. Of course, some Jews, no, I'm not a Nazi, I don't, agree with apartheid in Israel. But even if you allow the exceptional good Jew to denounce all the other Jews, those who refuse to disavow, you denounce them as Nazis, or even if you have the way it works is that sorry, I've lost my train of thought. Yes.
Well, Britain, as you know, doesn't have a written constitution, and it doesn't have a First Amendment protecting freedom of speech. So generally speaking, British courts are much more likely to entertain notions of group libel or to find generalized comments about a group offensive, which is why you have such a thing as libel tourism, where people who can't sue in the United States because the First Amendment protects hateful speech will go to Britain, where courts are more willing to declare certain kind of speech hateful. Now, given that background, I would have thought courts in Britain would have been bent over backwards to be more sensitive to anti-Semitism in the Ronnie Fraser's case. And the fact that they weren't is sort of doubly indicates that this was a very, very bad case to bring. Because if you can't be protected against allegedly anti-Semitic talk in Britain, you would have absolutely no question in this country where you get a First Amendment declaration. And Fraser would say no chance at all in the United States, I believe, in any kind of court, because you get into free speech.
Well, so imagine that it wasn't against Jews or Zionists. Imagine it was against women. Imagine you had pornographic pictures up and down the corridor in a university. Imagine that you walked into your university and you found the most sort of horrendous propaganda being made about, feminists and this and then. Imagine this happened within your own trade union. Imagine this happened in your workplace. It seems to me that one could put together a case to say not that this kind of pornography would be free speech, but that in this context, within the union, within the workplace, it would constitute a framework which would be hostile to women. It's not necessarily a free speech issue.
Is it the term that the court looks for in Britain, institutional discrimination?
Well, institutional racism...
They rule that criticism of Israel it's just too difficult a construct to say that if Ronnie Fraser were exposed to points of view that he didn't agree with, that would amount to institutional discrimination.
Right.
Not
but as you've seen...
Not whether he was offended,
right,
but whether it constituted...
But as you've seen, that wasn't what was happening, yes? The kinds of examples that I gave to you... Well, I don't agree. Because, for example, if Ronnie tries to engage in a debate about Gaza, yes? About, is there a blockade of Gaza, is there not a blockade of Gaza? And if he's simply denounced as being a Nazi, yeah, you're a Nazi, and that's just kind of generally acceptable, then there's no freedom of discussion. And this isn't a freedom of speech issue, right? Nobody's saying you can't stand on the street corner and say Ronnie Fraser is a Nazi because he's a Zionist.
I think it very much was a free speech.
But this is about the culture within my trade union.
In the U.S., the EEOC, I don't know the truth of the allegation, but if the allegations were true, the EEOC would say that that's a hostile workplace, and free speech notwithstanding, they could rule for the employee.
But they would look at whether a debate about whether Israel is a racist state is true or false.
No, they wouldn't, not at all. They
No,
would
of course
just,
not.
that would not be the issue. If
If
the response to people arguing one side of it was, you're a Nazi,
Oh, I see. But I'm talking about...
that kind of language would be considered derogatory.
Yeah, but our speakers bring up hypotheticals, which is great in the law school class. I'm actually concerned with the Ronnie Fraser case, and not with an alleged...
Well, I'm just responding to your point that in the U.S. there is a mechanism.
No, you're right.
Right, but there's a difference between the workplace and the union hall. You can say things in a union hall that you can't say in a workplace because the employer has almost complete control of what you say outside of work-related activities in the workplace. As far as the union hall goes,
I don't think that's true at all. I think within my trade union, if you tried to mobilise racist rhetoric, if you tried to say rap music was the music of the devil and should be, we should have a campaign against it, or if you tried to circulate pornographic material around the union, you wouldn't last 5 minutes. Wouldn't last 5 minutes within an anti-racist trade union if you tried to do that.
right, but that's not the employer that says that. That's the union itself that polices itself.
Correct.
That's what I'm getting at.
Correct. And in this case, the union...
Between the laws that govern the workplace or the laws that govern the union hall and what is done there. Whether or not they choose to do this or that is It's not the employer's choice, it's their choice.
So your argument is that the 2010 Act doesn't protect a union member from a racist union. Is that correct?
Right.
Anyone else? Okay, thank you very much.
So how does it vote?
Look.
And I hope you'll join us tomorrow night for a European Muslim
In the future, at some
anti-Semitism.
point, yes. Either being an apartheid state or with second-class citizens, or it ends up to being a state that restores the capacity of Israel to be Jewish.
Thank you for coming. Have some more dessert?
As you don't get a larger audience from the Jewish community.
Well, we did the last time, but the problem with tonight is that there's Yom Kippur things all over, and
Yeah,
you know.
yeah, I mean,
Let me just turn this off. I'm sorry.